All right. Guys, can grab some seats. Try to get started. Good. All right. Well, thank you all for coming and welcome. We'll try to get rolling, and then hopefully we'll have more time to discuss and chat, and maybe some topics to discuss in the process. So, thank you for coming. This is, as it says on the written wall, a joint session of the Portland Legal Hackers Meetup, which has been around for 2 years.
2 years, I think.
Yeah, we've kind of been on a longish hiatus, I would say, due to a number of factors, but we're obviously back. Legal Hackers, for those who don't know, there's sort of an international now group of organizations. They tend to be organized by city. It started out of a hackathon at Brooklyn Law School probably 4 or 5 years ago. And it has grown dramatically. I think it's at the point where, I think we're adding a couple of chapters globally a month to the Legal Hackers Network. So, and basically it's a group of lawyers and technologists and future-minded people working on ways to hack the legal system to increase access to justice, access to legal services, and basically try to make the world a better place, right? So I thought it was sort of a nice natural segue when Helen and Ray Haskell asked me to chair the Oregon Bar Futures Task Force Innovation Committee, which is a mouthful. It seemed like the right sort of thing because it has a similar charge of sort of harnessing technology, trying to be more forward-thinking, and again, increasing access to justice globally. So we had this wild idea that we'll kick off the committee in conjunction with the Legal Hackers Meetup. And we thought, there would be the sort of 10 formal committee members and then a bunch of advisory people. And we thought we might get another, 5 to 10 legal hackers. And then all of a sudden, 45 people showed up or signed up. So that's really exciting. And we promised to have a live stream. Unfortunately, my legal hackerness did not extend to being able to get the YouTube stream up and running, but I'm recording, so we'll be able to post this on. So sorry, world, for those of you who are going to catch this later. A couple of thank yous. So first and foremost, thank you to Jaguar Land Rover and Tammy, who's not here anymore, but this is their incubator for technology companies, right? I can't give you all the details, but Jaguar Land Rover has been in Portland for, I think, not quite 2 years now. Does that sound right to you?
Sounds right.
Obviously part of the expanding and vibrant technology scene here in Portland and in Oregon more broadly. Fisher Phillips is actually now the firm I work for, which is new since we had Legal Hackers Meetup. I am heading up their legal project management and innovation function. We're a AmLaw 150 law firm with a national labor and employment practice. So I've been working with attorneys all over the country trying to help them with process improvement and technology adoption and doing the things that we need to do in order to meet the demands of a growing and increasingly sophisticated client base. So Fisher Phillips has bought the pizzas and the snacks, and Land Rover has provided the space. So Jaguar Land Rover. So thank you to them. A few things, right, just in terms of staying in touch, if any of you are like live tweeters or anything else, seems like there's always one at a Legal Hackers Meetup, but there doesn't have to be. But if you are going to do it, right, PDX Legal Hackers is the Twitter handle for the Meetup group. My handle, J3, Alex, who will be following me to talk about design thinking in the law in a few minutes. And then internationally, usually when there's meetups going on, people use the legal hack hashtag on Twitter. We also have a couple of Slack groups that you might be interested in. So one of them is the Agile Attorney Slack group. This has turned into a really interesting group. So part of how I got started in all this is that I'm a big fan and proponent of agile philosophies and methodologies, capital A agile, which is a sort of a newer project management methodology that, and process improvement methodology that comes sort of initially out of the software industry, but is taking the world by storm. So we've got a few other folks from the Agile Portland group here too, which is nice. And then we have a new Slack group specific to the Innovations Task Force that is ospainnovation.slack.com. Right now, most of the people in there are either members of the committee or advisors to the committee, but I encourage you, if you're interested in participating about innovating legal services in Oregon, shoot me an email or tweet at me, and I'll invite you to the list. Unfortunately, you can't do direct signups in Slack still. But there's some good conversations that have been started already. We're going to be conducting most of the committee business using virtual tools to the extent that we can, right? So we're going to be looking at using, communicating in Slack. We have a Trello board set up already for helping to manage the projects. As we meet, one of the philosophies that we're trying to go with is we're going to have a remote-first mentality. We have members of the committee in LeGrand, in Medford, in Eugene, Bend, right? So in order that we don't disadvantage those people who have to come in remotely, everyone's going to be remote. So we'll be using either Google Hangouts or Adobe Connect or other things, right? So everyone's on a level playing field because I'm sure we all know what it's like to be the lone voice on the Polycom in a room full of people. It is a lesser experience, right? And so part of the way to make sure that everyone's voice gets heard and everyone has equal contribution is to put everyone on a level playing field, and that's one of the things we're going to try, right? We run lots of experiments when we innovate. We don't always get them right, but that's the idea. So, a few, icebreaker tech questions. Who here is attending their first Legal Hackers Meetup? Excellent, that's good. I hope you'll all be back. We'll try to get some new speakers and different topics and things, and try to get into a more regular cadence. Who's a lawyer? All right, so more than not, which is okay. I really like Legal Hackers Meetups that have a good mix of lawyers and technologists who also, so who's not a lawyer but works in the legal industry? A few, cool. Not a lawyer and not illegal. All right, not many, but that's good. Your voices are really important to this, and part of why I wanted to combine the Innovation Committee with the Meetup is to start to get voices in the community that maybe have new perspectives and different perspectives about approaching problem solving. So please speak up if you have thoughts or ideas. Who knows a little software coding? Good. I see many lawyers who raised their hands, so that's a good thing. Who knows a lot about software coding? Right? You could probably code an app if you needed to, maybe, or yeah. So a few people. I'm not one of those. I'm just exampling. I know a little. Who knows enough about the blockchain to explain it to a fifth grader? So, and I bring this up in part, and I wound up not making a slide for it, but is everyone aware that on Tuesday this week, the first complete blockchain-enabled, Internet of Things / blockchain-enabled contract began its execution? So a container ship full of cotton left a port in Houston and is on its way to China, and there are connected GPS devices that will be monitoring it as it travels, and as soon as it hits its port and is confirmed by the things, the bales, things embedded in the bales of cotton themselves, once it's confirmed that they have been delivered to the buyer, it will initiate a Bitcoin payment transaction back to the seller that will be completely sort of blockchain and Internet of Things enabled. Right?
What's the blockchain?
The blockchain is the technology that underpins Bitcoin, among other situations, and it's basically, so I'm not sure that I can explain to a fifth grader, but I'll give it my best shot. It's a public ledger that basically allows you to write information about different transactions to a universally accessible place, and you can then facilitate transactions in a public yet anonymous way to to make sure that, yes, people had the money that they said they have, transferred it, received it, and everything gets basically logged in the ledger along the way. It's being looked at as a means for handling copyright, right, music, it's really good for micropayments, right, for small value transactions that would otherwise have high sort of transactional costs. Blockchain is a very low transactional cost way of dealing with an executable. So that's my very nutshell, which probably exposes the limits of my knowledge. Right, so the Innovation Committee, right, I do want to talk a little bit about it, but I thought I'd throw this quote up here as sort of, well, this is something that I've often seen sort of thrown out among lawyers recently as sort of an inspirational thing that says we should be really embracing the future and getting out in front of things. The blog post, Larry Bridgesmith sort of brought to my attention, and he teased, you know, this could have been something written by Steve Jobs, this could have been something written by Bill Gates, but it wasn't. It was written by the ABA president, right? Which is kind of cool until you read it closely, and then it's actually not all that inspirational a quote, right? It's kind of like, the future's coming, I guess we better go, right? So, you know, there is this tension among lawyers in the legal system and the future, right? I mean, we are a profession that is sort of born and bred on the power of precedent and the importance of stare decisis and, you know, making sure that things are nice and consistent. And that's a feature of the legal system. We like that, right? Consistency is very important for people to go about their wares. But we run into problems when the problem-solving methodology we use, right, the case law method and precedent and all the rest, for practicing our craft leaks into the way we approach other sorts of problems, right? So one of the things that I really want to try to get people to think about is two things, right? Number one, there are lots of different problem-solving methodologies in the world, right? I mean, the case law system is probably one of the minority ones. There's the scientific method, and there's design thinking, and there's many others that we will talk about, right? And different methodologies are better or less suited to different types of tasks. The case law method is very good for establishing legal relationships and rights and case law and all the rest, but maybe not so good for running a practice, right? Doing things the same way we've always done it, because that's what I was taught by the lawyer who trained me, isn't going to get us even going with the future, right? That's kind of an anchor on us, sort of holding us back. So I'm not, please don't read this. This is something I hate to do, right? But I'm throwing it up there in part to just sort of get through a few things. I sort of broke it down. So the charge of the task force, and I'm going to nitpick a little bit, right, which is a lawyer thing. But a few other things that I'd like to just kind of, you know, words are important and order is important and things have meaning. And, you know, I just broke this out from the charge of founding the task force. But notice that the charge of the task force is to examine how the bar can best serve its members who come first, and better serve and protect the public who comes second. And I'm not saying that that's intentional, but it's not uncommon to see those sorts of orders of events when you're talking with, as I am now, a group of lawyers about how we should improve our practice. It's natural to be looking out for our own self-interest, right? But the bottom line is we are a self-regulated monopoly on the provision of legal services, and we do have a higher ethical duty, right, to support the public and protect the public at large. And, you know, I'm not saying that we don't execute that duty, because I think each and every one of us does in the service of our clients, but I'm not sure that we're not missing the forest for the trees. So I'll get into that a little bit more. A few other things from the task force, and I know it's hard to read the scenes, but looking at the influence of technology, exploring new models for regulating legal services. I like that. I won't be too crazy about that right now, but educating legal professionals, helping the public attain affordable legal services, and then innovations, right? To offer legal services in dramatically different and also financially viable ways. So thank you, Susan May, for informing my ability to break down this sentence into something of a statutory construction. And that was a lot of words, so I always like to break things up with a nice pretty picture when I do that. So the rest of the presentation won't be quite so intensive, I hope. Except we're right back to it, right? So the Innovations Committee, which is a subset of the task force, and the task force itself has two parts. There's the Innovations Committee and the Regulatory Committee. Many of the people here are on the Innovations Committee. I don't yet know who the roster of the Regulatory Committee is. I'm not sure it's finalized. It's not finalized, but we will be working closely with the Regulatory Committee because we are on the same task force. So we'll be looking at things together. But again, some of the things: growing sustainable practices for lawyers, responding to the demonstrated low and moderate income community legal need, innovative service delivery. I like that a lot. Providing more affordable legal services. And then also talking about lawyer business management, technology, and other practice skills. I will say one thing about number 3 real quick, and then and I don't touch on it in the rest of the presentation, but I do worry sometimes that we're asking lawyers to do too much, right? We expect lawyers to be certainly experts in the law, and as we all know, that's a full-time job. And yet, we also are expecting lawyers to be better and better at using technology, at understanding project management, at being able to run businesses, at establishing new business models, at being pricing experts, and using AFAs and all these things. It's a lot of hats to wear. And bigger firms can outsource some of those things, right? But smaller firms and solo lawyers really have some struggles. And I think really, I think it is certainly valiant to say that lawyers should be getting to know all of these things, but I think that we also need to be honest with ourselves when we need to ask for help. And so, again, I think there's a balance to be achieved in there somewhere, but I'm not sure that asking lawyers to just do more and more and more and more is going to be the right solution to that particular set of problems. So one of the things, here we go, that we've specifically been charged with is to explore the viability of an incubator program, right? So you saw my next slide already, right? So incubators, right? Nice, warm, cozy environments, maybe with or without holes in the floor for stuff to fall through. Right, the notion of an incubator is really sort of a nurturing environment. And, excuse me, losing my voice. The good thing is that incubators have kind of become a thing lately. So the ABA recently published this report, right? The comprehensive survey on legal incubators. A few things that we've learned about it, right? So this is sort of terrible information design, right? This should be incremental, and you can see what the total number of incubators is, but lawyers, right? Sorry. So there were 12 incubators in the U.S. So there's about 60 globally, 12 in the U.S. prior to 2014, about 34 since then, right? So the rate is accelerating. The average number of participants in an incubator program is 8, although it seems to vary from anywhere from 1 or 2 to 50. The average duration is anywhere from 12 to 24 months. It seems like a little longer is maybe more popular, 18 to 24 months. The average startup cost is $25,000. The average monthly expense is $12,500. Those numbers are kind of funny because there's a huge number, if you look at the report itself, the reported zeros for those, and they're included in the average, right? So maybe law schools or bar associations, whatever, are fully supporting them. So I think those numbers are probably a little low, but that's the data that's reported. But using that data, we can sort of sketch out in broad strokes what a legal incubator in Oregon might look like, right? So I made some assumptions, and I'm going to put big caveats around this whole next part of the presentation. It's easy to make numbers say what you want them to say, right? And these are all just guesses, but bear with me because I'm trying to sort of build a model that hopefully we can use as a useful starting point for discussion. So some assumptions, I said 10 new lawyers a year in a 12-month program, right? So maybe a little faster than the average. At the end of year one, so that each lawyer, we should ramp them up to the point where they can handle about 250 matters a year. Does that seem high to people? Yeah, okay. How many people does it seem high to? How many people does it seem low to? Okay. It's kind of what I thought. It's seemingly aggressive. I happen to think that it's totally doable. Probably not using the tools that we're all used to using, but we'll get there in a minute. So by the end of year 10, right, if we assume a little bit of attrition, so one of the things that the study says is that only about 70% of people go into smaller solo practice, another 6 go into nonprofits, and others scatter to the winds, and then there's sort of natural attrition. The incubators haven't been around long enough to have good long-term trends, but I've kind of assumed a 20% attrition per year in the model that I've built out. But still, at the end of year 10, we could have incubator lawyers handling roughly 11,000 or over 11,000 matters per year, right? And it kind of goes like that. The 20% attrition starts to knock us off, but still, we're talking about 11,200 people every year. So does that seem like a big number? For whom does that seem like a big number? For whom does that seem like a small number? Lots of people are not committing. That's good, because I'm baiting you. Right, but if it all goes well, right, lots of nice, well-formed, incubated lawyers running around in happy fields, right, and serving clients around the state of Oregon. But here's the problem. So another study that came out from the ABA this summer is that the conservative estimate is there are 100 million Americans at any given moment experiencing a legal need concerning a civil justice problem. Remember, most of these are civil justice problems concerning shelter, sustenance, safety, health, or child custody. Right? That's roughly 30% of the population, and that's the low end. So the study says well over. It actually cited other estimates that were as many as half of Americans at any given moment are experiencing a civil justice concern with respect to one of these 5 areas. Right? That's a really big number. And it's not a surprising number if you know this one, right? And if this was sort of in the news earlier this year. 47% of Americans can't come up with $400 in government emergency. And that's from the Federal Reserve, right? That's a formal government statistic. That's a surprising number. And Sam Glover from Lawyerist, I was at the Stanford Codex conference a few months ago, and he pointed out, it doesn't buy you a lot of legal work, $400. And also, you can think of a lot of things you'd rather spend $400 on. Now, granted, if it's related to your health, shelter, sustenance, maybe not. But still, that doesn't get you very far. And if you haven't read this article, I definitely recommend it. It is sobering. So we don't have good figures, in part because the last time an Access to Justice survey for Oregon was completed was in the year 2000. The last time before that was 1971. So we don't do these very often. We probably need to be doing them more often, and that's something that we'll talk about as a committee. But just to pick some rough numbers, if we extrapolate 30% of the population, Oregon's got about 4 million people in it. So we can basically estimate in Oregon there are about 1.2 million people every year that are having a civil justice problem that are either not accessing or not fully accessing legal services to support. Right? They may be getting bits and pieces here and there, but they're doing lots of things, and some of the studies bear out. Some of them just flat either avoid the legal system because they don't trust it, they don't think they can afford it, or they don't even know that they have a problem that could use legal help. Right? Education is a big part of it. So, right, our 11,200 divided by the need looks pretty paltry. So when we talk about, right, and that's in year 10, mind you. Also, it assumes that the need isn't growing as population grows, right, or other things happen. So, again, these are largely made up and estimated numbers, but I think we're in the ballpark here. So what do we do about it? right? One of the things that I keep coming back to, and right, trying to tie this into the theme of the night, which is design, is I think that the legal system is functioning more or less as designed, right? We're all doing our jobs. We feel like we're serving our clients really well. And that's where I sort of get into this forest for the trees problem, where I think we all have a perception, we lawyers have a perception that things are going well, and yet there's this nagging concern, and we keep seeing numbers, and we know that access to justice is a problem. But I don't think we're talking about the scope of the problem. So, sad. I looked for a sad chicken crack. That's the only one I came up with. And I'm a former copyright lawyer. I'm maybe a recovering copyright lawyer. I know that everything's Creative Commons unless I took the picture. So the question to me, right, and when we talk about access to justice, a lot of what I see in the dialogue and the literature, and even, we all get our Campaign for Equal Justice mailers and lots of things, is we've got to, figure out economically how to get more people into the system as it is currently designed, and I think that logic is flawed. I think we've got to start changing the conversation where it's not about how to get more people into the system as it exists. It's about redesigning the system to better work for the people who need it, right? So pin that for a minute, we're going to come back to it. But again, the need is huge, and this incubator is really just, as the hypothetical incubator, as we've discussed it, is really just an extension of the current thinking, right? We have lots of things that we've been doing in the industry that are kind of like that. And again, it's not to diminish the work that any people who might be in access to justice, either in this room or in the world, right? People are doing great work for lots of people, but it's just not nearly enough, right? The need is still giant, so there's a disconnect. So, and another way to think of it, right, is that the incremental improvement of legal services isn't enough. We've got to get to the point where we're improving geometrically, right? Step by step isn't going to get us there. So, a couple of other ways to think about this. I almost stepped on my own punchline. I missed my own punchline, right? So, we don't need an incubator. We need an accelerator, right? We've got to get things ramped up and roaring to the point where we are consistently improving our ability to deliver more services to more people at a lower cost and in a smaller time frame, right? So for those of you who thought that 250 seemed like a big number, it probably is using the tools and systems and methodologies that you have today, that we all have today, right? It also probably is considering many of the rules and regulations that we are currently subject to, right? If you think about a relatively small legal matter, just ramping that up and shutting it down has probably more than $400 worth of cost in most law firms, right? And yet, 47% of the population can't afford even that. So we've got to figure out ways to really sort of kick this thing in the rear. So one way to do it, so this is a different, slightly an adjustment on the model, is the idea that in addition to bringing 10 new lawyers in, we would actually build an accelerator that tries to actively increase the number of matters that each lawyer can handle by 20% a year. That's an aggressive number, to be sure, but I'm kind of talking moonshots a little bit here. So, right, and in year one, right, in some ways it doesn't actually translate to that big an effort because it's really only adding about 1 to 2% a month of capacity to the system. But it requires a dedication to continuously improving the system at that 1 or 2% a month. And then we can get to 20% a year. But if we could do that, and it's a big if, right, we get to the point where individual lawyers are able to handle, right, and by handle I kind of mean oversee, using a network maybe of certainly technology tools and systems, probably of different staff members, right, but creating more of a networked environment and a leveraged environment, right, where it isn't individual lawyers that are doing lots and lots of work on the case. The lawyer is more like the doctor in a busy office that has a receptionist and an intake nurse and a nurse practitioner or physician assistant that they're able to leverage to do much of the work. And the high-value, high-knowledge lawyer is sitting on the top doing systems design and troubleshooting and escalation path on truly complex issues. Right? So again, 250 I don't doubt is a big number. 1290 is a really big number. I don't think it's impossible. Right? I know that there are other systems in the world that are able to leverage high-value, high-knowledge resources far better than we have designed our legal systems to do it. And I think an accelerator has to catch on to that. Now, in this particular model, I still assume sort of the same 10 people a year with the same attrition. And so what that gets us to is a slightly better 7% after year 10. Better, right, than less than 1%, or roughly 1%. But still, in 10 years, we're still talking about over 1 million people with unmet need. So we have to grow geometrically in a couple of different axes, right? So the other thing that we need to do is figure out if we can build an accelerator, we have to be able to take what we learn about how to get those lawyers to their 1290 matters a year. Again, big if, but if we can do that or get anywhere close to it, and then spread the gospel, right? We've got to get converts, we've got to get other people on board, we've got to figure out how to really bring in other lawyers who may or may not have participated in the incubator. So in this model, I'm assuming that in addition to the 10 lawyers per year, we're finding another 30% of the population to grow and train and bring on board with the system. And again, rough numbers and everything. But that being the case, instead of, sorry, I forgot, 65 lawyers by year 10 who are doing this 1290 per year, we'd be talking about over 400 lawyers in Oregon doing this 1290 per year. So again, lots of assumptions, but 30%, it's not impossible. We could set up trainings and systems and programs and knowledge sharing and Slack groups or whatever it might be to really sort of bring more and more people into the fold of this accelerated way of practicing legal. And if we can do that, then we can solve almost half of the problem in 10 years. So, and I know that all sounds really hard. This looks a lot better to me, by the way, right? I mean, it's not perfect, but this is getting to where it's like, okay, it's kind of not embarrassing. So we've got to really be honest about what the need is and be far more open than we as an industry have been to addressing that need in new and innovative ways, right? And one thing, right, innovation, it simply means new. It doesn't always mean better, right? So one of the things that we also need to do is make sure that we're checking, right? Goal setting is actually one of the things that's great about using design thinking and scientific methods and all the rest is throw a hypothesis out there and try to hit it. You might fail to hit, these numbers that I'm talking about. They're big numbers, and we might fail to hit them. But we will learn so much more in the trying than we will using sort of the same old way of going about things. So we've got to find ways to try to get out there. So, right, I'm a big lean, agile person. One of the cornerstones of lean and lean manufacturing is the continuous pursuit of improvement, continuous incremental improvement. Kaizen is the term they use, right? But continuous improvement on multiple fronts is the only way we're going to crack this. The problem is bigger than anyone has recognized. But I'll get back to, right, the system as it exists today is basically functioning as we've designed it. And the question is, well, so one of the other things is efficiency or inefficiency in many ways is a feature of the system, right? So the whole notion of due process is basically an intentional slowing things down so that we can get people onto something of a relative footing. So there's a cost to due process, right? Conflict checking is another one, right? So there's a conflict checking is an intentional slowing down of the whole whole system so that we can do some checks and make sure that we're not sort of, putting ourselves into a personal conflict of interest, right? But there's certainly an individual incremental cost on each case. We happen to be representing clients who can kind of afford that. The incremental marginal cost of doing a conflict check for those who can already afford legal services is no big deal. But again, when you're talking about 47% of the population that can't come up with $400, that conflict check all of a sudden is really expensive. And so I'm not saying we should do away with conflict checks, but we've got to, again, re-examine, right, where we've created these intentional inefficiencies in the system. I think we have to do two things. I think we have to challenge our assumptions about the best way to go about them, and I think we have to challenge our assumptions about the cost-benefit analysis. Again, conflict check may or may not be the right answer, but there are lots of sort of parts of the RPCs, the rules of professional conduct, for those who are lawyers, that we have to abide by, that we could look at, that I think with a more critical eye, then we would be more open to changing in light of the scope of the problem. So again, design, right? For whom is the legal industry currently designed? Anyone want to take a stab at it, or a personal thought? Basically designed for lawyers, right? Who did the designing? Lawyers. So again, not surprising, and we're representing our interests, to be sure, and that's natural. We're representing the interests of our clients, as we should be. But what we are missing is that our clients are in the minority. It's those people who can actually afford our services, and we're designing the system in a way that protects them and protects their interests. By doing that, we're creating and adding to the barriers to entry for a whole subset of the population. So we got to think about that, right? It's possible that we might simultaneously be serving our clients extremely well and also failing broad swaths of society. And we have to accept that as true. It's not comfortable to accept that. But again, if we're going to make changes, we've got to start to realize that this could very well be true. All right, so a few other things, right, and then I'm going to pass it over. But this was an interesting number out of the 2000 Access to Justice survey in Oregon. 75% of people with a civil justice problem who were able to get legal help, most of them through legal aid or other sort of charitable path, 75% of those people felt good about the outcome of the legal system in their matter. For those who couldn't afford or didn't gain access to the legal system or to legal representation, 75% were dissatisfied, right? That's a huge binary. That's a good, we should take some heart in that. We do good work, right? We help people. We're not helping enough. Again, this is another, the ABA Futures Report estimates somewhere between 30 and 50% of a country is not accessing legal services, right? 75% people who don't have representation are dissatisfied with the system. So this shouldn't surprise anyone. 32% of this is likely voters, right? Feel like the country's on the wrong track. Your legal rights are meaningless if you can't enforce them. And we've got huge swaths of society that lack the knowledge, awareness, or means to enforce their legal rights. So, yeah, it sends us in an interesting direction as a country and a society. We think about who designed the system and who it's designed for. So, last thought I want to put out there, right, is that I think lawyers often think of access to justice as something of an economic problem. Right? If we could only get more money to hire more lawyers to help more people, then things will be better, right? But you've seen that doesn't scale. And I think so. One of the more comical things to me, anyway, that came out of the ABA Future Study is the notion that what we really need in this world is a civil Gideon, right? So Gideon versus Wainwright is the Supreme Court case that allows that people have a right to state funded defense attorney if you're accused in a criminal matter. Right? So a civil Gideon would mean that for certain, basically these 5, health, safety, shelter, child support, et cetera, that there should be a right to have a lawyer that would be a state-funded lawyer. But imagine for a second the political campaign to basically get that kicked off. So we need to take tax dollars from the people of Oregon and funnel them into this civil Gideon program so that we can hire more lawyers. Right? That one won't flow. We have enough time funding, hard enough time funding schools and things that are actually popular. So, again, we've got to come up with a different way of approaching it. I don't think it's an economic problem. I think accessibility, right? Access to justice is an accessibility problem, and accessibility is a design problem. And one way to think of it is this thing, right? And there's many examples like this. But this obviously is really important if you're in a wheelchair and you need to get through a door, right? You don't have many options for doing it otherwise. But what if you're pushing a stroller? It's not bad. What if you're carrying a lot of bags? Works pretty well. What if you broke your right wrist? The arm you normally pull the door open with. Or if you sprained an ankle and you're on crutches. Or if all goes well for you and you get old and you need a walker someday. So one of the notions out of accessibility design sort of concepts is that by designing for the lowest common denominator, right, the toughest use case, you actually improve accessibility for the rest of society in profound and meaningful ways, right? The ADA, yes, it has been very important for people that have true and permanent disabilities, but we all have temporary disabilities at various times in our lives, right? I mean, who's been to the gym or the sports bar and read closed captioning on TV because the volume's turned on? Right? You're temporarily deaf to that particular thing, and the closed captioning is useful and helpful. So if we can think about designing the legal services not for those of us that are extremely educated, right, made it through 20 years of education plus a bar exam and all sorts of other hoops and things we've got to jump through, right? I mean, we're pretty sophisticated people. But if we can design a system that are targeting the lower end, the margins, not only are we going to bring more people into the system who have those sort of disadvantages, but we're also going to make the system easier for the rest of us. And that will improve our efficiency and drive our prices down, our costs down, and actually will improve our ability to sweep in more people, right, into our services. It also will free us up to work on more complex problems and figure out how to friggin' e-file something, right? There are a lot of things in the world that we like to be chewing on these really high-end things, but we're stuck down in the mundane a great deal of the time. But if we can solve for some of those mundane things, then maybe we'll actually be in sort of a more interesting place. Right, so accessibility, and this is my bashing our particular systems, right? Sorry, but I don't know how we read this. This is the Oregon Courts website and the Oregon Bar website on my mobile phone earlier today, right? Not terribly accessible, right? Certainly not mobile optimized at this point, right? And you can obviously zoom in to read things a little bit better, but then you lose the scope of the whole thing. So it's a challenge, right? We need to be thinking more intentionally about these things. So again, accessibility, I think, is a design problem. And to talk a little bit more about design problems, and then we'll sort of open up to more broader discussion, I'm going to turn it